Today we have for you Adil Bashir, who is actually a friend of mine. He is a very talented lawyer. He works for the Federal Public Defender's Office. And right now, he used to do a lot of appeals work. Right now, he's working on sentencing policy for all the community defenders all over the nation.
Yes.
Yes. And the cases in your Crim Pro and probably your con law textbook, Yates versus United States. He was intimately involved in that case and has litigated before the Supreme Court. He has also been on the short list for a federal district judge position here in Tampa, meaning he got made it all the way up to the list of 5 names or 6 names that went up to the White House. And he also made the short list for the 11th Circuit, which the federal 11th Circuit, which is Florida, Alabama, and Georgia. And that name went up to the White House again. You actually went to the White House, right? And interviewed?
We do Zoom now.
It was by Zoom?
Yeah.
Oh, okay, interesting. Yeah, your first one was Zoom with me. Yeah. So he knows his stuff. He's going to be very humble. He won't say that stuff about himself, but I will. And he's very kind and gracious to do this presentation for us today. Supreme changes at the Supreme Court. We're going to do an overview of the 2023 to 2024 cases. And so without further ado, Mr. Adil Bashir.
Thank you so much. Thanks, everyone. And thank you, Professor Hardrick. So excited to be here with everyone. And I always feel, I love always coming back to campus. It makes me feel at home because I really do remember exactly what it's like to be sitting in your shoes. And I think you're at a very exciting time. When I was in law school, there was around the time when Heller was coming out, Second Amendment cases, things were changing. It was exciting, a lot of textualism going about. So you're really living in an exciting time from a legal perspective because as it goes, every generation, there's a different Supreme Court, there's different tendencies, moods, and the way that the Supreme Court operates. And it's really going to impact how your bar exam looks, with the way con law works, how your practice is going to go, whether you go into litigation, contracts, et cetera. And I always feel like the Supreme Court, it's a niche practice, it's interesting, it hits the news, but really at the end of the day, the skills that you're learning in law school right now are how to think like a lawyer, how to read cases, how to analyze cases. There's no better place to do that than listening to Supreme Court arguments, digesting their cases, and going and really trying to figure out how the court gets to where it's going to get to, both from policy and legal background. It would be impossible to talk about all 70 cases that we're going to be doing that were before the Supreme Court, or 65 from last term. So really trying to pick and choose kind of the key changes, and as the title suggests, the ones that really implicate doctrinal changes over this last year. Feel free to ask questions in between. If you want to save questions to the end, it's usually more efficient. But if there's something that's not clear or otherwise, happy to answer things in the background. So without further ado, figured we would start with a bang, which is probably the issue that is most animating this country right now and was most animating the Supreme Court in this past term, which deals with gender reproductive rights and healthcare. So just to take it a step back, the Supreme Court, when we think about in like lay terms, the types of issues, the types of cases that the Supreme Court takes, I'm sure everyone here is familiar. There's really two general categories. One is always going to be when you have conflicts among circuit courts. Those can range anywhere from really esoteric statutory interpretation issues, or case I was really involved in, a quirky statutory interpretation case about the meaning of tangible objects and fish, ranging from very big issues that are affecting criminal law, sentencing policy, et cetera, a lot of other things that we're involved in. The other really big area are big issues that impact national importance or national significance. We've kind of seen an uptick in the Supreme Court really grasping onto these big issue cases, probably taking them faster than they would have in the past, not letting issues percolate amongst the courts, taking cases that are starting from injunctive proceedings. So it's really changed a lot of the practice. You'll hear people talk about the shadow docket, the Supreme Court dealing with issues faster than district courts or courts of appeals have had a chance to really digest them. And abortion rights is really kind of at the front and center of these issues, because as you can imagine, these are issues that really require some rapid response, courts to get involved because lives are really at stake one way or another. There's two cases that I wanted to highlight, one of which kind of fizzled out, but both dealt with reproductive rights before the court. But they dealt with them in completely different ways. and in ways that only lawyers could really appreciate. Because undertone, we all know that these deal with abortion rights and abortion access, but the actual decisions in these cases really have nothing to do with either one of those issues, which make it a little bit interesting. The first one was the bigger case of FDA versus Alliance for the Hippocratic Medicine. So by just a show of hands, and I'm pretty sure you've all gone over this, how many people have gone over standing? How many people understand standing? I could use the pun. Who can't stand standing? So standing is one of these things that you kind of go over in law school and then forget about it for most of your practice. And then at some point it pops up again. And that's really what was under the undertone and underlying these cases. At the broad strokes, what this case really dealt with were access to generic versions of a medicine that was distributed, that could be distributed to women and other individuals dealing with pregnancy-related issues, anywhere up to about 10 weeks within the time of pregnancy. And really, I like to think of it as in the way of something that you and I probably do all the time. You know, if you're feeling ill, maybe it was a COVID time, you have a nurse practitioner, you have a doctor, you have someone who can usually just prescribe you medicine without you necessarily having to see that individual. How does that work? Well, there's all sorts of regulations where the FDA over the course of time says, this is the type of thing that we deem is safe for you not having to go in and have to go see a doctor, go have to sign someone otherwise. We're going to trust that healthcare providers can provide these over the phone or by mail, et cetera. Well, because of this particular drug and the issues involved, there's a group of doctors that quite literally formed an association, went to one particular district court, one particular place in the United States, for the sole purpose of filing a lawsuit to prevent the FDA from having this rule that allows access to these abortion medication. And I hesitate to even use that term because they're really healthcare medication, but prevent the access to that via phone or via mail or via anything other than in person. So really, again, what's underlying this is really access to this particular medicine. But what did the actual case really deal with? The case at its core dealt with, what's the first case that everyone learns in law school? Somebody say it loud. Marbury versus Madison, right? Because what there you go. Give her extra credit for that. Why is that case important? Yeah, because there's certain like fundamental things that courts are supposed to be doing. And a fundamental thing is courts decide cases or controversies. But courts aren't there just to deal with people who are aggrieved with bad things that are happening. For an individual to step foot in court, you need to have something that's just known as an injury in fact. You need to have, that is at its core, Article 3 standing. You need to be affected by the decision that's going on. So how are these doctors being affected? Well, this, for lack of a better way of saying it, probably I wouldn't necessarily say an A+, but maybe an A+ for outside the box thinking of creativity of where standing comes from. Groups of doctors, are they getting access to this medication? That's no. Are they required to distribute this medication to anybody? No. Do they necessarily have patients that are receiving this medication? They're obviously opposed to distributing it. So the answer is no. So you find yourself asking, in what ways are these doctors aggrieved by this care occurring? There's all sorts of medicinal care that happens all throughout the country. That's why, you can go to one doctor and get one type of surgery or another medication. So these doctors said, well, there's a lot of downstream effects. One of which is we think more people might end up in emergency rooms if they have to take this medication. And if they end up in emergency rooms, I may have to go work at that emergency room, or my district or my area where I have to work at might get overstaffed. And I might have to work some extra hours. And now you're listening where that downstream is going as a reason that I'm having this injury in fact. And I chuckle a little bit. I come from a family of a lot of physicians, and I think of my in-laws that are, and I know this is being live streamed, but hopefully he doesn't watch it, that are always complaining about having to cover when they're on call for their doctors. And nobody likes to have to cover an extra shift here or there. But that was essentially the theory of an injury. Other theories included, really this idea that there's a relationship between doctor and patient. And I, as an attorney, can sort of appreciate that. You can, and hopefully everybody in this room will as well, meeting with your client, talking to them face to face, making those type of decisions. By having this rule that you can just distribute medication without in-person visit, that's really taking away kind of the essence of what it is to be a doctor. The third one is quite possibly, it will be taught in law school, I hope, as just an example of a really wild theory of standing. There's no other way to put it. This idea of aesthetic injury. An aesthetic injury is doctors really love being around pregnant people. And they love looking at the sonogram and they like looking at babies. Who doesn't like babies? And if you take away, there's one hand. So you would lose the standing argument right off the bat. But this was an in fact argument made that by taking away an in-person requirement to receive medication from the doctor, that doctor is being deprived of the joy that they receive or other doctors may receive from interacting with pregnant individuals. All real life arguments made in real life court that made all its way up to the Supreme Court. So everything we've talked about right now has very little to do with whether or not the medication itself induces an abortion, causes an abortion, what the time limits are, et cetera. All of this really the entire case really had to do with this idea. Do these doctors even have the ability to challenge this regulation? And critically, as we understand how the case developed and it got to the Supreme Court, by the time it got to the Supreme Court, there was a really general understanding that to win or lose on this case really had to depend on that injury in fact, that standing proceeding. And before you ever read opinions, I always encourage people, there are oral arguments. Sometimes it's great to go back and listen to arguments after opinions come out, but certainly listen to the arguments because the justices typically ask a lot of hypotheticals and test the limits of arguments in ways that other courts do not. One, for just timing purposes, and two, the Supreme Court is really just testing the practical implications of individuals' argument. So here, the oral argument really kind of walked through each one of those standing issues. And we're asking questions of the government that was defending this regulation and saying, well, are there conscientious objection exemptions for doctors that don't have to distribute this medication? Yes. What about, let's assume for argument's sake, there's going to be lots more people going to emergency rooms. Are there ability to have those places staffed? Yes. Do we know in advance, what if I typically don't mind covering for my colleagues, but if I have to cover for them because there's more people coming in because they have access to abortion medication, that's going to be a problem. Well, we have conscientious objection for that as well. Well, each one of these things was being covered one by one, and the court really landed on the fact of saying, the most lay way you can say this, looking at the challengers, what is your problem here? And really, so on that standing basis, issued an opinion that ultimately ruled in favor of the government and dismissed the case or ruled that these challengers did not have standing. They did not have an injury based on traditional standing principles because they couldn't show that they individually were being impacted by this particular ruling. The second case that also dealt with abortion access care really had to do with federal preemption, and that case was dismissed as improvidently granted, which is a rare thing that happens in the Supreme Court. But the 32nd version of that case really dovetails nicely with the other decision, is that the court was looking for ways to decide these really thorny issues on narrow procedural grounds. Deciding a case on federal preemption is about as narrow and thorny and standing as you will particularly find. So always look at the high level, what's going on, but what's underneath the surface are really going to be these kind of essential legal issues.
So just a fun fact, a lot of students haven't taken con law yet. Some of them are brand new, some of them have, so just keep that in mind.
Yeah, so most people here have not taken con law. Let me not jump the gun here. How many people have taken agency law?
Leg reg. They're in leg reg.
Oh,
we
they
call
are.
it leg reg. Yeah.
Nice. Very nice. People are familiar with the Chevron doctrine.
Everybody who took my class, hands go up. Okay.
And everybody that's taken compliance.
Hands go up. There we go.
Yeah.
I'll just stick.
Okay. a really big case in this last term, and something that has been percolating its way up to the court for a number of years, is an attack on the administrative state and really courts' ability to scrutinize and invalidate agency regulations. So a number of you have taken the class, but for those that haven't, or just to refresh your memory, the Chevron doctrine is one of several doctrines that really how courts interpret agencies' interpretation of their own rules or statutes or regulations. And Chevron dealt with how an agency would, the way it typically works, or the way it works in most circumstances, Congress passes a law, and that law has some type of either delegation or rule or some type of promulgation that a federal agency then is charged with administering. And a lot of times, and more often than not, there are gaps because Congress can't possibly write every single rule. They don't have the expertise to do that. They quite frankly don't have the time. And agencies fill those gaps. And sometimes they have the express authority, and other times they don't. And Chevron was really a case that said, well, what do you do when there's ambiguity and you can't really decide what the agency regulation meant? And Chevron, for lack of a better way of putting it, is really just a presumption or a deference, saying rather than courts really stepping in and trying to figure out all this mess, if an agency has a reasonable interpretation of the rule or regulation, they have the expertise, they have the background, we're just going to defer to that interpretation. So it's really a deference doctrine at its core. And that existed for many years until this year in a case called Loper-Bright. And Loper-Bright ruled that Chevron is overruled. And it's rare when a Supreme Court case actually expressly says a case is overruled. Sometimes they'll try to find reconciles other way around, but we don't want to have any ambiguity here. The Chevron doctrine is no more. And instead, the rule is now that courts have to exercise their own independent judgment in deciding whether an agency has acted within its authority as the Administrative Procedures Act requires. So the case was really decided on kind of statutory grounds. There's an Administrative Procedures Act that kind of governs how all of this works. And the court said, well, in that Administrative Procedures Act, Congress went back and they never said you have to defer to what an agency says. They said courts, that's the role of the court. So going back to that first question, what's Marbury versus Madison? These are like super basic principles that really are still permeating on the highest levels of the Supreme Court 200 years later. Oh,
if I can ask a question, what
Sure.
does that mean for like how agencies operate now?
The reason that this was such a big deal is, as you can imagine, and just take some hypotheticals, big agencies that regulate lots of things, the EPA, the DEA, the FDA, these are agencies that all the time are issuing rules, regulations that affect business, how much you can pollute, what kind of caps you have on safety mechanisms, et cetera. Right now, agencies had a lot of authority because every time they had these gaps, whenever they came up with an interpretation, 99 times all they were shooting for was reasonable. Reasonable is a very low standard compared to the best or the top reading. From administration to administration, depending on, especially an executive, a president's authority could really direct federal policy in ways that you didn't have to go back to Congress. Now, the whole ballgame has changed. Two important caveats to that. The Loper-Bright decision expressly said any case that previously relied on Chevron is still good law. So you can't go back and challenge old regulations. That's a very weird thing that the Supreme Court did, but you can do that when you're the United States Supreme Court. Typically, when you overrule a case, it overrules other cases that relied on it. But the Supreme Court has some practicality in mind. They didn't want to open up Pandora's box. But ex ante going forward, agencies have to completely change the way that they write their regulations. And they are now fraught with, well, there's a whole host of rules. If we come out, let's say tomorrow, the EPA comes out with a new regulation that impacts businesses and the amount of waste that they can dispose per month in a particular river or in an area. Well, that no longer will be subject to what the agency thinks is reasonable or what the agency follows. And a litigant can go directly to court and say, if you look at the text of the statute, this agency doesn't have the authority to do that. And the real issue here is that Congress when they wrote these rules for 30 years, wrote these laws with Chevron in mind. They wrote these laws understanding that agencies would fill the gaps. That's why they have these delegations and gap filling, assume these gap filling measures. Now that that presumption is gone, perhaps it'll change the way Congress goes forward, but more likely, because I don't think it's controversial to say Congress doesn't exactly move at a lightning pace or is not as responsive as one would hope to a lot of the issues of the day. It's going to take a long time for Congress and the courts to catch up, particularly if the result is what you want, is agencies to be anemic and not be able to be that responsive. Yes.
And another issue with that is that the agencies sit under the executive branch.
Yes.
So that clouds it up even more. So you've got the court saying, well, agencies shouldn't do that. Congress is writing vague laws. Agencies are implementing the laws, and the agencies are not under the congressional branch of government. They're under the executive branch. So now you've got all three branches muddying up the water to get things done. And I know in my textbook, there were cases where the Supreme Court said, we don't intend for you to choke the courts with all of this stuff. Let the agencies figure it out. So now they've said the agencies can't figure it out. So, what happens when we need to change something for the U.S. Department of Education now? You just they're kind of in no man's land.
Yeah, no, that's an excellent point. And I'm going to get to the Second Amendment in a second. And I think it's sort of a canary in the coal mine for what happens when Pandora's box is open, because we're really in uncharted territories, but we're also, because we're in a different point in time. But the way the court explains it, in your textbooks, there's a case, I'm sure it's in your textbooks, I have not checked. There's a case called Skidmore. Yes. Skidmore was one of my favorite cases before, because Skidmore stood for the proposition before any of these Chevron or other cases that an agency's interpretation was as good as its persuasive value. So it was just another piece of the puzzle, another pie that you can use. That Skidmore case, as just a predictive exercise, I think is going to become a lot more robust. And the court very likely, as the professor was saying, what tends to happen when these huge doctrinal changes, very shortly after, the court has to go right back from the next case and kind of clean up what they just did. And we really just saw that. We had the Dobbs decision, and then right after Dobbs, we had a slew of abortion rights cases, cases that were undermining the Voting Rights Act. We'll talk about that in a little bit. We've had a slew of challenges there. And in the Second Amendment, we'll get to a second as well. Whenever you have these big changes, you kind of have these, you have an earthquake and then you have the aftershocks. And the court has to rein back on what they just did, because there are unintended consequences. And one of the bigger unintended consequences here is we just don't know. There are a lot of really good rules and regulations out there that keep people safe. How many people fly? Every time I fly, I'm always amazed. I'm just at some point during the flight thinking, this is amazing how safe this actually is. Well, the FAA, but then we hear stories about Boeing and, falling off of planes or whatnot. I mean, the slightest bit of regulatory futility, we've seen it in the railway industries, et cetera, could cause catastrophic consequences. And that's not what anyone really wants at the end of the day. So it'll be really important to kind of go forward and see, where the court goes next, because they can't just overrule something and leave it at that. All right. So the next kind of category, and it is fun that former President Trump has its own category. We were joking amongst those of us who kind of do this on a regular basis that the Supreme Court, this term had to really have like a Trump week. It was kind of like their own convention for all the different cases that were implicating.
Were they all heard in the same week?
No, but they should have.
Okay.
They really should have just, block. Their docket needed to block off an entire length of time to deal with these cases, because this is not in a situation where you have conflicts among circuits, because how many former presidents, you have different decisions, or anything like that. And we actually have very few decisions that deal with presidential powers or presidential immunities. But there's two big cases from this past term, and both. I think at their core, you can look at them as the cases that will be studied for years and years as separation of powers cases. Mm-hmm. And really under this court kind of grappling with two very challenging things from their perspective: a very hot political climate and people looking to the court to be quote unquote saviors or give us answers. and the court responding with, go ask somebody else. The Supreme Court, I think, in many instances, wish they did not have to take these cases and really wanted to resolve these cases in a way that took the court outside of politics. But some things are just inevitable, and that's what the courts are there for. So the first of these cases was Trump versus Anderson. And this dealt with the efforts by states to, and Colorado in particular here, to remove former President Trump off the ballot for his alleged involvement in January 6th riots, insurrection, whatever terminology we want to call it. And what made this particularly interesting is in our system, as we'll find out again in this November, elections are done at a very, very local level and done by states. And by constitutional design, states are the ones that decide how their elections are run, how electoral votes are tallied. We're kind of used to the common system. I'm sure if you Google it or go look at the news right now, you'll see there's one or two states, I think Nebraska is one of them, that apportions out their electoral votes. There's all sorts of different quirky ways in which things go, how people get onto ballots access. You can make a lot of money in the future if you learn how to do this, because this is a hot issue of election law. A question that really never had come up is, what if a former president or a president in general was involved in any type of insurrection, was disloyal to the United States? Is that the type of person, through different provisions of the Constitution, could be removed or disqualified from being on a ballot? This case ultimately decided that the state could not remove the president off the ballot, and really was limited to the president, not any subordinate officers. If you had people running for state senate, you have people running for federal senate, House, none of those are implicated in the decision here. The focus and the way that the court worked it out is, sure, there's a constitutional design that allows states to set their own rules, but that's not self-executing. And it's a really fancy way of saying the Constitution says that this is a power, but they don't say how it works. That's for Congress to decide. So there's some balance of power and how this all works. And until Congress passes a statute that kind of tells us what meat on the bones, so to speak, the state is without authority to operate. Probably is news to a lot of people, probably would be news to the founders who designed the Constitution, because I don't think for 250 years anyone really thought that's the way that it worked. But once again, the Supreme Court, I think, was really trying to come up with a way, and a simple way, to say, how can we ensure that this is not going to become a political tool, tit for tat, of one party trying to remove another person's major presidential party candidate? I got an idea. Let's say we have to have Congress come up with a rule, because that's something that will never happen. And that's really kind of a design, because for better or worse, if Congress rule, it would most likely be some bipartisan rule. There would be some uniform agreement. If there was obviously a constitutional amendment, that would have even more consensus. So underlying a case is really, again, this idea of federalism, but there's really this politics that was underlying it. That was kind of the lesser known case, because it came, it went, it was pretty quick. The bigger of the two cases had to deal with presidential immunity. And this was a really not only huge decision, it's one of, I think, less than a handful of cases that we'll probably ever have that really dealt with presidential power and how the ability of individual courts or other branches of government to keep a president in check for his or her authority. And in Trump versus United States, on the question of presidential immunity, what makes this case really interesting, and especially from kind of an appellate practice, which I do for a living, these cases started with the prosecutions in DC under the January 6th indictments. These are the Jack Smith indictments in the DC circuit. And the arguments were made there that the president is absolutely immune from prosecution, because the simplest way I can put it, it's, the old Nixon line: if the president does it, it's legal. And everything that happened in relation to January 6th, challenging the election, et cetera, were all within legal power and presidential powers at the time. As the case progressed up, they lost in the DC District Court, they lost in the DC Court of Appeals. The case was petitioned to the US Supreme Court. The US Supreme Court granted the petition. The first case was brought by the government, asking preemptively for a ruling from the US Supreme Court. can you tell us what the limits are of presidential immunity so we don't have to waste our time going forward? Supreme Court did not grant that petition. After this got all the way through the DC circuit on kind of an expedited schedule, the Supreme Court granted cert. Kind of a fact that I think is often missed in this case is usually the way it works is when you petition to the Supreme Court, you literally on a form write what your question presented. It's the first page of any Supreme Court petition. Go look at one. And that question presented, you're telling the court, what is the question you are asking us to answer? In this case, the Supreme Court rewrote that question when they granted cert, when they granted the case. They did not grant the question of absolute immunity. They granted a slightly different question, whether and to what extent the president enjoys immunity for official acts committed while in power. And why that was so important is, and this is just, semi-pro tip, but something that you will see in a lot of Court of Appeals opinions, probably more so than the Supreme Court. The way a party frames their issue is as important as the arguments that they put forward. Sometimes something went wrong, but you're looking for what's the legal hook? What's the way that I can win this particular case? The lawyers in this case did not raise an argument that framed it in these kind of narrower terms of official acts and whether and to what extent, a very kind of like typical Supreme Court way in which they decide these issues. But the Supreme Court, sua sponte, means on their own, raised that question. The minute they did that, most practitioner court experts understood the way that they framed the question answered it, because it's whether to and to what extent for official acts. Well, for official acts, they have immunity because that official act question was never really presented before the court. This is another case where the oral arguments are absolutely wild. They're really kind of frightening and fun to listen to at the same time, with hypotheticals about what if SEAL Team 6, what if the president orders SEAL Team 6 to go shoot their political opponent? Well, it would depend if that was an official act. Well, what do you mean is that an official act? Well, there's other regulations that say SEAL Team 6 can't do that. Well, what if you say you're going to shoot that guy who said they're going to follow those acts? And there's all these other types of different guardrails. And President Trump's attorneys really tried to make an argument that this would curtail the ability of a president to do anything if you're scrutinizing his or her decision-making ability. On the government side, what was interesting here is wasn't a full-throated, no, you should be able to hold the president accountable for anything. There were a number of, I think, valid concessions that were made that said, look, if these are within constitutional authority, express powers, the power to pardon, the power to sign treaties, et cetera, that are in the Constitution itself, those cannot be prosecuted. Who am I to critique individuals that are far more knowledgeable about the Supreme Court? I'm not sure I would have made that concession, because you could be impeached for corrupt pardons. Why can't you be prosecuted for corruption, even if it's in the course of making a pardon? But that's neither here nor there. Those concessions were made. Once those concessions were made, you can hear the court just kind of going down that slippery slope and it's kind of a caution to everyone in this room, be careful of the concessions you make before a court, because once a court latches onto a little bit of a concession, they can go even further. And long story short, taking that line of concessions down, the court really got to the point of saying, how do we draw this line? How do we know what's official? It's an official act done in an individual capacity, et cetera. And ended up issuing an opinion on the very last day of the court's term on a Monday, if I remember correctly, which is rare. So they sort of waited till the absolute 11th hour for an opinion that established really two things on the parameters that ultimately were not in dispute at the end of the day. One was that the president enjoys absolute immunity for things within their constitutional authority. And on the other end of the spectrum, a president is not immune for individual personal acts. And then everything else in between is this wild gray area of official acts. And what are official acts? We'll find out sooner than later. But not only that, official acts are immune, depending on what those are, but also the things that sort of make up official acts. So if my Secretary of State or Attorney General, I am talking to make a decision that may or may not be an official act, that is an official act. That's within presidential prerogative. That can't be used as evidence to show an official act. And the opinion really at its core, pretty much eliminated the possibility of prosecuting anyone, let alone a former president, for anything other than really just an individual outside of the presidential prerogative shooting someone on Fifth Avenue. And even then, I'm not entirely sure that that wouldn't somehow be related to an official act. So here's some just criminal law cases, but my area of interest, more practicing criminal law. But the biggest one from this past turn is a case called United States versus Rahimi. And this is what I was previewing a little bit earlier when we were talking about the Loper Bright case and really what comes next. So Rahimi is really the second act of a pretty landmark decision from previous term called Bruin versus New York Pistol and Rifle. And Bruin is a very fundamental case in that it established a different Second Amendment standard than had ever been in history, that said the Second Amendment regulations, courts are to not use some type of means end scrutiny. I'm going to use that terminology and then explain it. Means ends. It took me forever. Don't feel bad if you don't understand. It took me forever to realize like the definitions in the term itself. Means ends means that you pass a law, a means to accomplish some end. The end is usually safety or national security or something like that. That test is not what you use for gun regulations. You don't ask whether or not you're burdening somebody right to possess a firearm because it's good for society, it would be safer, we don't want to have kids to have guns, etc. Instead, what you have to ask is whether or not a regulation is consistent with history and tradition of what the Second Amendment regulated at the time of the founding or Reconstruction, depending on the time frame, whether it's state or federal. As a criminal defense attorney, I can tell you I've done dozens, if not more than dozens, of Bruin trainings throughout the United States for rooms like this with criminal defense attorneys saying, all right, guys, remember all those years we have firearm cases and we didn't know what we can argue? Now we can just argue that the regulation is not consistent with history and tradition because they didn't have these laws in 17. None of these laws really existed until, and especially all modern federal firearm restrictions didn't come into existence until like the 1930s for the most part, if not the 1960s. One of those laws was the offense at issue in Rahimi. And Rahimi dealt with this statute, which is 18 U.S.C. 922G. You don't need to know that now, but if you ever become a federal criminal defense attorney or prosecutor, you will have it burned into your head because it's the most federally prosecuted case in the country. And it has very numerous sub-provisions. And what it just says is you cannot have a gun if you fall within any number of statuses. So if you are a convicted felon, if you're in the country illegally or unlawfully, if you're a habitual drug user, and G8, as we like to call it, if you are subject to a domestic violence restraining order. And Mr. Rahimi was an individual that was subject to many domestic violence restraining orders. He has a problem and he cannot stop committing domestic violence. However, he still wanted to have a gun. And the Fifth Circuit Court of Appeals agreed and said under Bruin in 1776 and otherwise, there were no laws regulating domestic violent offenders from possessing firearms. So Congress cannot pass a law doing that now. And so this is where the pullback happens. The Supreme Court takes a case very shortly after Bruin comes out, and in this case, and the adage you've probably learned in law school, bad facts equal bad law. These are dangerous facts equal dangerous test. And what the court held was, well, I know we said you have to go back to history and tradition, but we didn't really mean literally what history and tradition. Instead, the court ruled that history and tradition supports that if individuals found to pose a credible threat to safety, they can be temporarily disarmed under the Second Amendment. And what they did was they really clarified what they said in Bruin. Like, this is what we wrote, but this is really what we meant. What we meant was when we said go back and look at precedent, we didn't mean that, and these are direct quotes, that they were not meant to suggest the law was trapped in amber. And rather, the Second Amendment permits not those regulations that are identical, but that are closely related. You don't need to have a dead twin or historical twin or a dead ringer to that law. So it kind of changed your like 30,000 foot like analytical framework. And they came up with this other test that wasn't really used in Bruin, but they're saying, so you've got to find a law that's relatively similar to those the laws back in the 1700s. And in Rahimi itself, this is for like real bonus points. Does anyone know, if you've read the opinion, what types of laws they used to analogize the domestic violence restrictions? I couldn't even make it up. Surety laws. And
I don't know what that is.
surety laws. I don't think the court knew what they were.
Insurance?
Surety laws are, they were rules and regulations from like the 1700s that allowed individuals to basically, if you had grievances or redresses against other individuals within the community, you can impose fines, you can restrict their rights in other ways. And there were certain surety laws that allowed, if somebody was known to be a violent in the community, a drunkard, they were posing problems, they could have their liberty taken away, and they could be temporarily have their firearms taken away. And from that logic, Justice Roberts, who wrote the majority opinion here, said that's close enough of an analogy to the concept of if you are a domestic violent abuser, that you can have your Second Amendment rights taken away. So that really changes kind of the analytical framework then looking, because what defense attorneys throughout the country and individuals challenging regulations were doing, we kept saying, hey, under Bruin, there is no law from 1700. Now it's shifted back to, that's not a valid argument. Instead, you have to say it's not like the types of things that were regulated in the 1700s. And that level of abstraction makes it much, much harder to challenge these individual laws. But this isn't the last we're going to hear of it. There's a cottage industry right now of cases before the Supreme Court or petitions that are challenging Second Amendment regulations under Bruin and even under Rahimi. So stay tuned for the next case. It'll probably be whether AR-15s are weapons in common use and could be regulated under the 1700s framework. And also whether felons can be disenfranchised, even if they're not violent, because Rahimi talked about violence. And this is really just saying, so these are all the things that Rahimi didn't hold. They pulled back, but they left open a lot of different questions, using firearms in self-defense, common use, etc. Permanent bans, that's another one. And this is just a chart I like to have that kind of shows the progression of where the Second Amendment has gone from what the next case and my prediction, which I think will be preventing individuals who threaten physical harm. That's where the court is really going to. These two here, I think, are worth mentioning, and they're both on the civil side, but they're going to impact our ability and our democracy and otherwise. And the first is a major voting rights and gerrymandering case, Alexander versus South Carolina State Conference, the NAACP. And I'm sure everybody here has heard the practice of gerrymandering, understands what gerrymandering is. If you don't, raise your hand, I'll explain it. I think everybody here knows what it is. What's significant about this case is the Supreme Court for years and years has sort of been curtailing back the ability to challenge racially disparate map drawing in the practice of gerrymandering. And with the Supreme Court, and it's a kind of the theme that I would leave you with here, when you look at the Supreme Court, they're dealing with high-level issues, but they're deciding them on very technical grounds. And here, there was a challenge to South Carolina's map for being drawn, gerrymandered, but drawn for a pure racial disparate reason to dilute the population of votes for African-American individuals vis-a-vis other individuals in the state. And what the Supreme Court said, it didn't say is that's bad or no, you shouldn't do that or anything like that. What the Supreme Court ended up deciding is you, district court, so the lowest, the first level court, that said that this was a racially drawn map, used the wrong standard in how you evaluate that question. That is a fact question that has a legal implication, but those are factual questions. So you can only review that, and the Court of Appeals can only review that if there were a clear error or if there's something plain and obvious in the court's rule in using race. But if there's other things going on, but there's other legitimate reasons, and the practice of gerrymandering, even for partisan reasons, isn't in and of itself illegal, then just because race is involved, you can't make that the predominant issue. It has to be under this very deferential, very technical, clear error standard. And by ruling in that way, the Supreme Court didn't endorse the practice, didn't say they liked it, didn't say it was good, but essentially said it's impossible or virtually impossible to challenge absent a direct, hey, smoking gun, we want to have less Black people voting, which, believe it or not, does happen. There are sometimes in emails, you'll see that in trials when they're trying to strike individuals from jurors. There's famous cases where even recently you actually will have that smoking gun, but absent that smoking gun, it's going to be next to impossible to be able to challenge maps that have the same racially disparate effect, but that don't have that underlying basis. So again, a ruling here based really on the standard of review rather than the merits of the case. And the Supreme Court basically also said that giving gifts to officials is fine. It's like, what's the big deal? And these are like all sorts of like little fun examples. And again, essentially saying here that, look, there's regulations. I work for the federal government. We can't accept gifts more than $50, things like that. Like, you have rules, regulations that deal with that, but making it a federal crime to accept a gratuity for something, I mean, sometimes your constituents are just nice to you. I don't know how many there was a hypothetical here. What if your professor takes you? How many of your students have taken you a steak dinner? Any professors here have been taking a steak dinner? You guys are not. The Supreme Court is telling you this is a common practice.
Danilo said he got me. So.
The $100 and spending $100 at Dunkin' Donuts is that's not an easy thing, but go for it.
But for judges, those of you who've gone on trips to judges, you notice I can't bring them a gift. There's a reason why I don't bring a gift to them. I'm not allowed to. So that is so was it with Justice Thomas? Did those issues come up? Because he was in the news a lot for receiving all kinds of gifts.
Yeah, and those are all regulations. Actually, we're subject to the same thing. I fill out that same form every year. I'll cut him a little bit of slack and saying it is a really complicated form, even for an attorney. Like, it is unnecessarily complicated, the things that you have to disclose. But I also don't have a $250,000 RV that I probably would. But if I had multiple, maybe I would forget to put one on there. I think he's disclosed those. But I'll conclude by one of my favorite topics in con law. And I think I wanted to end on like kind of a positive note. A positive First Amendment decision. And these were two consolidated cases, Moody versus Net Choice. And what these cases dealt with is there were several states that passed laws that regulated how social media platforms, Facebook, YouTube, etc., moderated content. There were claims and accusations. These cases came out of Florida and Texas that these platforms were regulating content of particular viewpoints, whether it be conservative, moderating content of anti-COVID, vaccine views, et cetera. So the state passed laws on how these platforms could moderate content. And in an opinion written by Justice Kagan, who I think is one of the best writers on the court, so you should definitely read her opinions, vacated these laws and said they were in violation of the First Amendment. Why? For a very bedrock and basic principle that hopefully doesn't come under attack under this court, and this is a good decision that gives us hope, and said on its core, on its basic level, the way social media platforms work, it's really no different than the way newspapers work, in that there are editorial decisions made all the time about the types of content that people see. What's different is Facebook, YouTube, et cetera, uses really complicated algorithms that feeds you exactly what they think you want to see. And they make all sorts of editorial decisions all the time based on what you click, how much you look at. They're screening your eyeballs and how long you look at something. This is true. It is all part of it in the case. And they're making those type of decisions. The government has no ability to come in and say, you have to do this in X, Y, or Z way. That is outside of the government's authority. The First Amendment protects the ability. If you had a platform that just, you guys are probably too young, but when Facebook first came out, there were no such things as algorithms that pushed out what you wanted to see. There was just a pure timeline. That's why it was called a timeline. That would just tell you, oh, if somebody posted something at 12, then 12:01, 12:02, it would be in a sequential time. That all started to change to give you content that you wanted to see. And these cases set under the First Amendment rules that tell anybody how to edit the content, platform, or moderate regulation. Those are all in violation of the First Amendment. And one thing that the Supreme Court has always been very consistently strong on is on the First Amendment exists to protect speech that we may not disagree with and we may not like. But at the end of its day, for democracy to function, you have to allow speech in all of its different forms, and the market is free to create forms that have other types of content that people are interested in. I know there's some other kind of major cases out there as well, but there's been a lot of talk and word that there are important First Amendment cases that the Supreme Court may start chipping away at, but cases like Moody versus Net Choice kind of give us hope that the Supreme Court will keep that very important role of individuals being allowed to speak and speak their mind on platforms, and platforms themselves being able to be marketplaces of ideas to still exist. So with that said, now we got a little bit over. Can I talk a lot?
Yes. No, it's all good. We appreciate you. We'll kind of end the meeting and give Mr. Bashir a round of applause for his time. I want to thank you all for showing up and showing out. This is a full house. I know it's warm in here. So are you good on time to hang out and answer questions?
For a couple minutes.
Okay, for a couple minutes. Yeah, so we'll take some pictures. If you want to be in the picture, hang out. And he'll be back next month. So if you want to ask questions then, you can do it then. Make sure you sign the attendance sheet if you want your credit. Thank you so much. All right, so we're going to show you the CLE number so you can get your CLE credit. Thanks so much for joining us during the Esquire CLEs for our members. And we'll see you guys next time.